This morning's docket. Case number 106805, State of Kansas v. Joshua Quested. Did I get that right, counsel?
Yes, Your Honor. And he appears in person, he appears in counsel, Michelle Davis. And may I reserve 3 minutes for rebuttal, please?
3 minutes is granted.
This is also an issue of statutory construction, and fortunately we have mostly one statute to deal with. It's a claim of an illegal sentence based upon consecutive sentences. And the Kansas statute governing multiple sentences is KSA 214608. Primarily governs this issue. There's a second, and that statute in some form or other, statutes governing sentences have been around for decades. The second is the statute that came in with the Kansas sentencing guidelines regarding multiple convictions, and that's 214720. But a good starting point in this case is the WH case, a very thorough legislative history from 2002. And what WH tells us is that in 1855, the common law regarding consecutive and concurrent sentences was abrogated by statute. And at that time, it was required consecutive sentences. 2 or more crimes, the sentence for one didn't begin until the sentence for the other ended. And that was the law, according to WH, from 1855 until about 1863. And then they cite the statute in WH in 1963. Let me say that again, 1855 to 1963. In 1963, when you had 2 or more crimes, it then became discretionary with the district court whether to impose concurrent or consecutive sentences. And at some point, we got to the statute that we have today. The statute that we have today says that, and this is 214608A, it says that when separate sentences of imprisonment for different crimes are imposed on a defendant on the same date. So then that qualifier got put in there. Because the legislature could easily have said, when separate sentences of imprisonment for different crimes are imposed on a defendant, comma, a judge shall have discretion. But instead, the legislature put the qualifier in on the same date. And that basically limited when the district court had discretion. So we have a situation here. Mr. Quested's claim was there are certain situations where consecutive sentences are mandated under 214608. For example, if you commit the crime on parole, if you're on a felony bond, if you're on probation, if you're incarcerated, on post-release, the district court has to impose a consecutive sentence. In this case, the sentences were committed approximately the same time period. And so he didn't qualify for any of those criteria. The remaining statutory provisions say that in certain circumstances, the district court has discretion to impose concurrent or consecutive sentences, and that would be the situation that I already talked about if you're being sentenced on the same day. If the district court has discretion to run the sentence concurrent to a sentence in another state or federal sentence, and that's 214608H. And then the third situation would be what came in with the sentencing guidelines in 1993. And that would be 214720, and that would be multiple convictions within a case. And in that circumstance, the legislature still limits the district court's discretion, because what the legislature says is that it caps the discretion. The district court can't sentence to more than double the primary crime. The district court has to find the primary crime, which is the most severe. The district court can only apply full criminal history to that primary crime, and the district court can only sentence to double. So you can have a defendant that goes out and commits 17 felonies if they're all within the same case. The court's discretion is limited. So the sentencing guidelines took even more control away from district courts.
What if there are separate cases but all on the same date?
Right, then you would fall within the, arguably.
So they're not
Arguably.
capped. They're not capped by 4720, are they? By the double rule.
Right.
Or are they?
I read that statute to be within the same case. And so for example, in this case, if if these sentences had been within the same county, I think the argument still remains the same, that none of the if he committed these crimes and the state had charged him in two separate cases, there's still no authority here for consecutive sentences. Because he doesn't, unless he was sentenced on the same day. In both cases.
That was his hypothetical.
Oh, I'm sorry, I misunderstood.
Didn't you say?
Yeah, the same date.
Okay.
You have 17 felonies on 17 different cases, but they're all consolidated for the same date sentencing. And then your double rule wouldn't apply, would it? Or would
If they're in two separate cases.
Two separate
So
case
that's where I
numbers.
got confused. I thought you meant one case. We have two separate cases, and he's not on bond, on parole, on post release, whatever, and they're not sentenced on the same date, then there's no authority for consecutive under the statutes, whether it's in a different county or whether it's in the same county. So I think what I need to do.
Can you address the whether we do have any common law sentencing?
Well, WH makes it pretty clear that beginning in 1855, you have statutes that have governed this issue.
Does it make it clear as to adult criminal sentencing, or do you think that reasoning is limited to juvenile?
Well, no, I think it makes it pretty clear that this is, I mean, why would it give the full legislative history unless to say that this, I mean, I think WH doesn't qualify.
Where I'm coming from, I think we can all agree that we no longer have common law crimes in Kansas.
Yes.
The criminal code displaced all common law crimes. My question is, do we have common law sentencing? Because we've had some statutes that say sentencing is strictly a creature of statute. If there's no authority under the statute, there's no authority, which tells me that there isn't common law sentencing rules.
Well, that argument may work if all the statutes did was talk about consecutive sentencing. I mean, that was kind of the basis behind the Chronister, which is the 1995 Court of Appeals case that said the legislative intent, the legislature wouldn't have intended this result. But you have statutes that talk about when a judge has the discretion to do this. So really, they've abrogated that area of the law also. I mean, they're not just said you have to do it in these cases, but they said we're going to give you discretion in these other circumstances. So they've covered the whole spectrum there.
He's just asking the global question, though. Is all sentencing a creature of statute now?
Well, I believe it is. Yes.
We have case law that says that, don't we?
Yes. I mean, I think everything's fairly statutory now. And I mean, my search on that mostly was civil cases, but I know there are criminal cases out there that say that.
So what happens
There's a-
here? I'm trying to play this out in my mind. We have which is not an unusual occurrence, is you have multiple cases from multiple jurisdictions occurring within the same time period, but on different dates. We have sentencings going on at different times in different counties or different judicial districts. And now the court must remain silent on whether or not those sentences have anything to do with other sentences imposed in other places. You can't say concurrent, you can't say consecutive because the statute doesn't say anything.
But that's right. Yes.
So what happens?
Well,
So you finish, I mean, what happens?
well, unless they're sentenced on the same date.
No, I understand. Let's say there's, so
But they're not-
what
it's not sentenced on
happens?
the same date.
The trial judges are now to ignore the fact that there's other cases out there. What happens to your clients who have a sentence here and a sentence there, and they serve one, then they serve the other, they overlap, or what happens?
Well, I mean, yes. I mean, without any express authority.
Yes, what? I mean,
yes,
what happens?
Then they would run concurrently because.
No, I mean, why would they run concurrently?
Well, because they would be, in fact, serving both sentences at the same time.
Well, what if one overlaps the other? Let's say we have a 32 months in one sentence imposed in January, and then in April, we have a 5-year sentence. So they kind of overlap, but you still serve everything just overlaps.
Each sentence would start from when the judge ordered that it was sentenced and given jail credit.
So they just
and the
all
sentence
stack
would
up, and
begin.
whatever's the longest is what's served.
Right. right?
Which is, okay.
And I mean, you know, I understand that's what Chronister said, is that the legislature wouldn't have intended to do away with the district court's discretion, but that's what they did. I mean, when they brought in that language about on the same date, that's exactly what they did. And that language goes back to at least the 1981.
So it's
From
restricted
what I can
to,
tell.
so it's just restricted to crimes that occur on the same date.
Or out of state, or federal. That's a
state.
specific statute that grants discretion if there's another crime that's in another state or federal.
Right?
And I know
Right.
sometimes things don't make sense, but how does that make sense?
Well,
That if it's out of state or federal crime, you can have discretion to run the consecutive, but it's in a different judicial district, you don't.
but the same thing works if you commit multiple felonies, the district court is capped. Versus this court has said you can go out and commit multiple misdemeanors and the judge can run them right after each other. How does that make any sense that it's better for a defendant to commit multiple felonies than it is to commit multiple misdemeanors? Because there's no cap on misdemeanors.
Well, the distinguishing
And it's
fact
the
in
same
his
thing.
question is that a out-of-state or a federal felony will be served in a different penal institution than two different counties.
Well,
I mean,
yeah,
so it is
right.
factually distinguishable. Whether it makes any sense or not, it's another thing.
Right, but I mean, that's, if you read that language, that's true. I mean, the whole purpose is that you're going to release it to that other jurisdiction to serve the time. That's really what's going on with that statute. And I mean, one of the purposes of the sentencing guidelines is to reduce prison overcrowding. So I assume that's why the legislature is limiting the court's discretion to impose consecutive sentences.
When everything is said and done, you still come back to our case law that says the sentencing of a criminal defendant is strictly controlled by statute in Kansas.
Yes.
And if it doesn't make sense to us what the legislature has done, the remedy is to go to the legislature and change it.
Yes. Yes. I mean, the remedy here is with the legislature. And as I said, that language about the qualifier on the same date has been around since at least the 1980s. In the case of Chronister, they cite the Reed case, and they talk about the 82 change that came in where bond, it had to be consecutive, and the 81 statute is in the Reed case, and the 81 statute is basically the same language you have today. It has to be sentenced on the same date. So, I mean, this isn't anything, the legislature at some point made that decision to put that qualifying language in, because it wasn't there in 1963. And at some point between 1963 and 1981, I mean, that language is intentionally put in there.
If we see this your way, does any defendant currently serving a sentence consecutively have an illegal sentence claim?
Not any defendant, again, because the statute.
If the defendant shares the characteristics that you're saying control in your case.
Right, yes, yes.
Any further questions? Any further presentation?
No, thank you.
Thank you, counsel.
May it please the court, Christina Trochak, Assistant Saline County Attorney, appearing on behalf of Appalachia State of Kansas. The state in its brief is asking this court to adopt the rationale in Chronister. Certainly, this rule is subordinate to the statutory construction rule, is subordinate to the rule that judicial interpretation must be reasonable and sensible to effectuate legislative design and the true intent of the legislature. And as
What is that true intent?
Well, I think the true intent was when they amended the statute in 1982, they wanted to make certain that it was clear that there were circumstances that require consecutive sentencing.
And they didn't include within those circumstances the fact that you'd been sentenced in another jurisdiction. They didn't include that.
That would require consecutive
Right.
sentencing? No.
And they didn't in 60 or whenever, they added the same date language.
Yes, I think to clarify the court's discretion in cases that occur within the same jurisdiction and maybe in separate cases, but they're sentenced on the same day.
And why would they need to clarify that and that would indicate to us that it also meant if they were on different dates in different counties, it's to be treated the same. I mean, why does that show us their intent to do that?
Well, I think that it indicates that there was some clarification, but I think also we can conclude that their intent was not to completely strip the district court of discretion in imposing consecutive sentences in cases that occur in separate counties. Dixon County is right next to Saline County.
Well, they took away quite a bit of discretion. For one, they have no discretion on imposing consecutive sentences if certain things happen, such as if he had been on bond for the Dickinson County, then there would have been no discretion. He would have had to have the latter one. So there's plenty of instances in that Sentencing Guidelines Act where the legislature has taken away trial court discretion.
To adopt that rationale, though, would lead to absurd results. Because you commit your crimes, as in Chronister, he committed crimes in Harvey County and Sedgwick County. Because you commit them in separate counties as opposed to the same county, then the court is devoid of any discretion to impose consecutive sentencing. That is not a logical result, and the state submits that was not the intent of the legislature. The intent, again, of the legislature was to define those circumstances where consecutive sentencing was mandated on the trial court, and to clarify situations within the same jurisdiction when you have separate cases but they're sentenced on the same day.
Well, do the same limitations apply, such as the double-double rule and those kinds of considerations when you're dealing with consecutive sentences from different counties?
No.
They don't apply, so you could just stack them up and have a string of felonies and get a 300-year sentence. I mean, but you could get.
And you could get that type of sentence too if you're committing those same crimes in the same county in separate cases.
Well, you're limited by certain restrictions, but you're saying those don't apply when we're dealing with different counties and running consecutive.
They don't apply with different counties, but the state's position is they don't apply with separate cases, either within the same jurisdiction. The state would not be limited to, or the trial court or sentencing court would not be limited to the double-double rule if you're talking about the cases in separate cases.
Let's review some rules of statutory construction. Okay, you would agree that we have plenty of cases out there that say that the appellate court is not supposed to interpret a statute based upon what it thinks the law should be.
Correct.
And we have cases that say that we are not permitted to make vital or omit vital provisions of a statute or add vital provisions of a statute, regardless of what we may think legislative intent was. That's up to the legislature to fix. We've said that.
You have, yes.
And we've said that, I won't try to use the Latin, but when a statute includes one, it excludes others. So for instance, a statute that says discretion on out-of-state and federal, that names those two, but it doesn't include an out-of-county.
That's correct.
Okay, and we have a rule that says we use strict construction of a penal statute, the rule of lenity.
Correct.
Okay, so to counter that, the only counter that I've heard to all of those rules that would put us where defense wants to be is that you consider, or you want us to consider it absurd.
To consider that a reasonable construction of the statute would be that the legislature did not intend to strip the sentencing court of discretion in those scenarios. It certainly makes no sense that the legislature would intend that.
But we have case law that says if there are two constructions that could be labeled as reasonable, that we have to select the one that favors the defendant under the rule of lenity. So we have to find more than it would just be reasonable to construe it your way. We would have to say to not do so would amount to an absurd result.
And I'm stating that it would amount to an absolutely absurd result when a defendant, the court would have discretion to sentence a defendant who commits 3 rapes in Saline County to consecutive sentencing. But if that same defendant commits a rape in Saline County, Dixon County, and Geary County, the district courts would be without any discretion to impose consecutive sentencing. I submit that's absurd.
Other than the avoidance of absurdity canon, do you have any legislative history that helped us out?
Well, if you look at the legislative history of the reason for imposing certain mandatory requirements of consecutive sentencing if they're on felony supervision, I don't know at this point in time of any other legislative history that would be helpful.
And nothing when the on the same date language was added?
Nothing that I can cite
Okay.
right now to the court.
Thank you.
I'm having trouble with the absurdity argument. The difference between if he had been on bond on the Dickinson, it would have been mandated by the specific terms, but if he's already sentenced, it's not. And why didn't they make the latter part of that mandatory? And when they didn't, why do we suspect they just overlooked it?
Well, I think that maybe a little more guidance can be found in the fact that it's certainly still discretionary if you commit a crime in Kansas City, Kansas, and you commit a crime in Kansas City, Missouri, that the trial court or sentencing court can impose consecutive sentencing in that regard, but could not impose it if both crimes were committed in Kansas City, Kansas. I still submit, and I certainly not trying to be obtuse, Justice Johnson, but I submit that to interpret that as anything other than absurd is not reasonable.
You don't see the rational basis for distinguishing when if they did the crime in Kansas City, Missouri, they would be serving that sentence in a Missouri Penal Institute versus Kansas City, Kansas in a Kansas Penal Institute, but 2 different counties would put them in the same penal institute, that there is a factual distinction in those scenarios?
But there is a slight factual distinction in terms of where they're serving the sentences. But certainly, the bottom line is they've committed crimes in 2 different states, and the state of Kansas would have the authority to impose a consecutive sentences, but would not if those crimes were committed in the same state.
Just so I'm clear, are you in agreement that all sentencing is controlled by statute in Kansas?
I think that that is the conclusion that we're probably left with.
So you're not
considering
able,
the case law.
so you're not able to stand here and say that your position is supported by the common law, therefore it would be authorizing the court. You're trying to get yourself into, well, if all sentencing in Kansas is controlled by statute, then there are statutes here which we can interpret that would grant this authority.
Yes,
And your position is to do otherwise would be an absurd result.
yes.
Okay, thank you.
I don't have any other argument to submit unless the court has any questions.
Any more questions?
Otherwise, I will ask this court to affirm the district court's imposition of consecutive sentencing in this case. Thank you.
Thank you, counsel.
I just think in the interest of full disclosure, I don't think this situation actually happens very much, because generally with multiple cases, multiple sentences, defendants usually are out on bond, or they're on parole or probation, and or they're within one county and the cases are all treated together and they all get sentenced together. So, well, yes, I think this is an illegal sentence. I think it has limited application.
I'm not sure I understand that. Why doesn't it apply anytime there's a sentence while the defendant's still serving a sentence on another case?
Well, because most of the time they were out on bond.
I don't know that that's true.
Or, Well, usually there's some time period between those cases. In this case, it's just unusual in the sense that these both happened at the same time. So
I think that is an unusual fact situation, but I think this has the potential to apply to innumerable cases.
Okay.
I mean, I just can't, Judge Malone will be able to tell us more recent experience than my fairly long ago experience in the district court, but it was very frequent that you would sentence someone to a sentence consecutive to another sentence. That
In a different county, originating in a different county.
Yeah.
Plus the crimes that occur in penal institutions.
Right.
I mean, those
that's
definitely
consecutive.
affect, the rule that you're asking for would definitely affect those.
Well,
If
I
the
think
person
that's-
happens to be serving a sentence from a
think-
district outside where the penal institution is
Well,
located.
I think that's covered by there's a part of the statute that covers if you commit a crime while you're incarcerated, it has to
Okay.
rank consecutive.
Okay,
Isn't
there's-
that
so there's a
mandatory?
mandatory one on
Right.
when you're in it.
So
Okay.
there's a lot of
I stand
consecutive
corrected.
rules out there that cover a lot of situations.
Okay.
And generally when crimes happen within a county, they tend to all get lumped together into one complaint, or they tend to get treated together. So if you're in the same county and
Yeah.
you're a prosecutor, it's in your interest to do that. But
Does the fact that sentencing has occurred for some number of years contrary to the statutory authority render the plain language construction absurd? In other words, does impact on a whole bunch of cases render our decision absurd?
No, and plus if we're gonna go back, some of these defendants have already served that time anyway. So,
So you're saying that we can't rely on Chronister as the law of the state that everyone's relied on for decades?
well, Chronister, the reasoning of Chronister just doesn't hold up. Because, as I said, they're saying that the legislature would have intended this result, but, the legislature did create this result. And so, it just doesn't do any real statutory interpretation. It just sort of says, well, we just don't like the result. And so yes, I think Chronister's wrongly decided.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Take this matter under advisement.